discussion on Criminal Procedure Code. In this session, we will discuss that is reciprocal arrangements for assistance in certain matters and procedure for attachment and forfeiture of property. This chapter 7A that has been included by way of amendment in the year 1988, and thereafter again amendment was there, that is year 1993, that came into force from 27/1994. What it provides, what do you mean by reciprocal? Reciprocal means that is an agreement between two or more persons to do something, for mutual assist, do something for their advantage. That is reciprocal. Both there is agreement. Here reciprocal means an agreement between the central government of India, government of India and other contracting state for certain matters. Certain matters means what? For execution of warrants, assistance in securing transfer of persons, assistance in relation to order for attachment of forfeiture of property, identification of unlawful acquired property. For that, some mutual assistance will be given by this central government and the contracting state with which there is a contract between the central government and that state, that their warrants will be executed here in India and warrants issued by courts in India will be executed in the contracting state. So that is chapter 7A deals also procedure. First, in section 145A, you find some definitions. What is definition? In this chapter, unless the context otherwise requires, if it is otherwise requires, then the contracting state, first it has been defined, contracting state means any country or a place outside India. Contracting state means a country or a place outside India in respect of which arrangements have been made. Contracting state, any country or any place outside India in respect of which an arrangement has been made by the central government with the government of such country through a treaty or otherwise. There must be a treaty or otherwise. Then only that country or that place will be treated as contracting state as per the provisions of chapter 7. What is? Any country or a place which is outside India with which there is an arrangement. Arrangement has been made by whom? By the central government and that country or that place by a treaty or otherwise. Second, the identifying includes establishment of a proof that the property was derived from or used in the commission of an offense. So here identifying has been defined, that is establishment of proof. Identifying means establishment of proof that the property was derived from, that the property which was identified was derived from. Identifying means includes. Simply identification is not sufficient. Identifying includes the establishment of proof that a property was derived from or used in the commission of offense. The third is proceeds of crime. What is proceeds of crime? Means any property derived or obtained directly or indirectly by any person as a result of criminal activity. So proceeds of crime means any property derived or obtained. Any property derived or obtained. There are two words, derived and obtained. Obtained means something somebody has brought. Derived, that is directly. Derived or obtained directly or indirectly by any person as a result of criminal activity. So that will call proceed of crime, any property obtained or derived by any person by criminal activity, including crime involving currency transfer crime, that is also property derived, or the value of any such property. Even direct property is not available, the value of such property, that will also be treated as proceeds of crime. Any property derived or obtained by any person, by any criminal activity, and also including crime involving currency transfer, that is from Indian money or Indian currency was transferred, from this dollar was transferred, or the value of any such property. Now, what is property? Property means property and assets of every description. Here, property, you see, property or assets of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and deeds and instruments, even documents and instruments, evidencing title to documents and instrument evidencing title, that will also be treated as property to or interest in such property, title or in document or instrument evidencing title or interest to such property, or assets derived or used in the commission of offense, any assets which have been derived by committing an offense, and includes property obtained through proceeds of crime. Property obtained through proceeds of, with proceeds of crime as through that any property is obtained. So here, tracing means determining the nature, source, disposition, movement, title or ownership of property. All has to be tracing, not physical tracing of the property. Also means determining the nature, source, disposition, movement, title or ownership of property. So these definitions are there for reciprocal arrangement. You know, that is clear, you should go through it. Now, 105B says, assistance in securing transfer of persons. First, this is a reciprocal arrangement. Sometimes a person is to be brought from a foreign country. Similarly, a person who is required for committing an offense is to be extradited to another country. So, what is section 105B provides the reciprocal arrangement, that is assistance in securing transfer of persons. What it says? Where a court in India, in relation to a criminal matter, suppose a criminal court, in relation to a criminal matter, desires that a warrant for arrest of any person to obtain or produce a document, desires that a person for arrest of a person, desires that a warrant for arrest of a person or to produce a document or other thing issued by it shall be executed in any place in a contracting state. Contracting state means, you know, any country with which there is an agreement, or that is a treaty, there is a treaty, or otherwise there is an arrangement made by central government with that government. So that is contracting state. So here, when the court in India desires that a person is to be arrested by virtue of a warrant, or a document is to be produced, or any other thing is to be produced by virtue of a warrant, then it shall send such warrant in duplicate. Then such warrant will be sent in duplicate in such form to such court, judge or magistrate through such authority as the central government may by notification special in this year. So that will be sent to the court in that country. And that court, judge or magistrate, as the case may be, shall cause the same to be executed. So if central government has made any rule that the warrant for arrest a person, warrant for production of a thing or a document, that is to be, which is to be executed, that is to be executed in a contracting state, then that warrant will be sent to that court, in the court of that contracting state, through such authority as the central government specify notification. Then, in such case, such magistrate, such court shall cause the same to be executed. Now, Similarly, notwithstanding anything contained in this code, if in the course of investigation or inquiry into an offense, an application is made by the investigating officer. Sometimes that investigating officer, while making investigation, finds or desires that some person is to be arrested there. So that subsection 2 provides, notwithstanding anything contained in this code, in the course of an investigation or an inquiry into an offense, an application is made by the investigating officer. If an investigating officer files an application before the court, or any officer superior rank to the investigating officer, suppose a superior rank to the investigation, that the attendance of a person who is in any place in contracting state is required. That the investigation officer files an application to the court, that an attendance of a person who is in a contracting state, his attendance is required for the purpose of investigation. In connection with such investigation or inquiry, and the court is satisfied that such attendance is required. Thereafter, on hearing that application, the court is satisfied that the attendance of such person is required for the purpose of investigation or inquiry. Then it shall issue a summons. Then the court shall issue a summons or warrants in duplicate against the said person to such court, judge or magistrate in the same form as the central government by notification specified this. Then in such case, the court will send a summons or such notice, the warrant in duplicate to such court, following the notification, following the rules, if any, made by the central government to that effect. And in such case, such court, and by notification, specify this to cause the same to be sought or executed. Where a court in India, similarly, suppose a court in India, in relation to criminal matter, has received a warrant for arrest. Suppose Indian court has received a warrant of arrest from a court in contracting state to arrest somebody, requiring him to attend and produce a document. Similarly, suppose court in India has received a warrant for arrest of any person, requiring him to attend and produce a document or other thing in this court, in that court, or before any other investigating agency of that contracting state, issued by a court, judge or magistrate in a contracting state, then the same shall be executed. Then in same manner, the same shall be executed as if it is the warrant received by it from another court in India. So as if such warrant has been received from another court in India and for executing within its local limits. Where a person transferred to a contracting state pursuant to subsection 3, suppose transferred to a contracting state, a person will be transferred, is a prisoner in India. He is a prisoner in India. Suppose a contracting state requires the attendance of a person and the warrant has been issued against that person, but he is a prisoner in India. The court in India or the central government may impose such condition as the court or government deems fit. In such case, before surrendering, before transferring that person to the contracting state, the court or the state government or the central court or government may impose such condition. With such condition, he will be transferred. Where the person transferred to India pursuant to subsection 1 or subsection 2 is a prisoner in a contracting. Similarly, suppose the Indian court has issued a warrant for arrest of somebody and to produce to a court in contracting state for his arrest and to produce. Similarly, when that person is a prisoner in that country, in that contracting state. Similarly, where the person transferred to India pursuant to subsection 1 or subsection 2 is a prisoner in a contracting state, then the court in India shall ensure that the condition subject to which the prisoner is transferred to India, if any condition has been imposed, there was any condition for why such a prisoner, when a person was prisoner in another contracting state and he was transferred to Indian court, then the court shall ensure such conditions are complied with and such prisoner shall be kept in such custody subject to such conditions as the central government may direct in writing. Now 105C says, assistance in relation to orders of attachment or forfeiture of property. Sometimes the court in India passes order for attachment and forfeiture of property. and if the property is in the contracting state. Similarly, suppose a court in contracting state sometimes passes order for forfeiture or attachment of property which is in India of a person. In such case, what will be the procedure? Where a court in India has reasonable ground to believe that any property obtained by a person is derived or obtained directly or indirectly by such person from the commission of offence. Court in India believes the person has derived any property or obtained any property by committing that is by directly or indirectly by committing a crime from the commission of offence. It may make an order of attachment or forfeiture of such property as it may deem fit under provision of Section 105D to 105J. 105D to 105J deals about the forfeiture of proceeds of crime. Proceeds of crime, or that is any property derived from committing a crime. So here, similarly 105C says this power is given to the court, where a court in India has reasonable grounds to believe, there is reasonable ground for the court to believe that any property obtained by a person is derived or obtained directly or indirectly by such person from the commission of an offence. It may make an order. What type of order? To attachment or forfeiture of such property as it may deem fit under the provision of Section 105D to 105J. Following the provisions as per Section 105D to 105J. Now subsection 2 says, where the court has made an order for attachment or forfeiture of any property under subsection 1, and such property is suspected to be in a contracting state. But the court in India, when court in India will pass order for forfeiture and the attachment of forfeiture, that the court has reasonable, that the court in India has reasonable grounds to believe that any property has been derived by any person by committing a crime, by committing an offence. Then the court will pass an order for attachment of forfeiture. Suppose that property is in contracting state, that is outside India. This subsection 2 provides, where the court has made an order for attachment or forfeiture of any property under subsection 1, and such property is suspected to be in a contracting state. Then the court may issue a letter of request to a court or an authority in the contracting state for execution of such order. Then the court will, instead of one letter of request, will be sent to the court where under whose jurisdiction that property is suspected for execution of that order. Where a letter of request is received by the central government from a court or an authority in a contracting state. Similarly, so when central government receives any letter or a court or a central government from a court or an authority in a contracting state, central government receives, say, a letter of request from a court in contracting state requesting attachment or forfeiture of property in India, derived or obtained directly or indirectly by any person for commission of an offence committed in that contracting state. Then the central government may forward such letter or request to the court as it thinks fit for execution accordance with the provision of Section 105D to 105J. The procedure to be followed for forfeiture and attachment of property, attachment and forfeiture of property derived from by committing an offence, we find such procedures there from 105D to 105J. Similarly, suppose the central government receives a letter of request from a court in contracting state for what? For that is attachment or forfeiture of property, then central government may forward such letter or request to the court as it thinks fit for execution in accordance with the provisions of Section 105D to 105J. Now, up to this, we will find 105C, all are reciprocal arrangement so far as transfer of prisoners, transfer of persons involved in commission of a crime, or order of attachment, assistance for order of attachment and forfeiture property. Now, Section 105D says what procedure is to be followed for attachment and forfeiture of property derived by committing an offence. Section 105D says identifying unlawfully acquired property. Identifying has been defined. How it has been defined? Identifying doesn't mean only for identification, but also includes establishment of a proof that the property was derived from or used in commission of an offense. Derived from, used in the commission of an offense. That is identified. So here, the court shall, under subsection 1, on receipt of a letter of request, under subsection 3 of section 105C. 105C provides when the court can pass order for attachment, the court shall, under subsection 1, or on receipt of a letter of request under subsection 3, that the central government has received a letter of request for identification of her, that is attachment and forfeiture. In such case, the court, on receiving that, direct any police officer not below the rank of sub-inspector of police to take all steps necessary for tracing and identifying such property. That is, proceeds of crime. As reason to believe that a property has been derived or obtained by committing an offense. Then, as per section 105D, the court will direct a sub-inspector of police, not below the rank of a sub-inspector of police, to take all steps necessary for tracing and identifying such property. Second, the steps referred to in subsection 1 may include any inquiry, investigation, or survey in respect of any person. So when the sub-inspector of police is directed by the court to take steps for tracing and identifying such this property which has been obtained or derived by committing a crime, then such sub-inspector shall take steps. That steps may include any inquiry, investigation, or survey in respect of any person, place, property, assets, documents, books of account in any bank or public financial institution or any other relevant matters. The sub-inspector will do all such, they shall take all such steps for make a survey in respect of the person, go to that place of property, assets, documents, books of accounts. You can may include any inquiry. Such inquiry can be done by that sub-inspector of police. Now, any inquiry, investigation, or survey referred to in subsection 2 shall be carried out by an officer mentioned in subsection 1 in accordance with such direction issued by the state court in this plan. That means not below the rank of a sub-inspector. That inquiry doesn't mean only identifying, even tracing the property, even identifying that property and taking all steps which are required, even to verify documents, books of account in bank, all such things. So that's such steps will be taken by the sub-inspector of police as per the direction of the court. Now, 105B says, seizure of attachment of property. Where an officer conducting an inquiry, who will conduct the inquiry? The sub-inspector of police will conduct an inquiry. What for? Court has directed as per section 105D, the police officer not below the rank of sub-inspector to take all steps necessary for tracing and identifying such property. Once he makes an inquiry, then or investigation under section 105D, has a reason to believe that any property relation to which such inquiry investigation is made, conduct is likely to be concealed. Sub-inspector of police, the investigating officer, the person who is making such inquiry has reason to believe that property in respect of which he has been directed to make inquiry to trace that property is about to be concealed or transferred or dealt with in any manner which will result in the disposal of such property. He may make an order for seizure of such property. Then such officer may order for seizure of such property, and where it is not practicable to seize such property, if it is not practicable to seize such property, he may make an order of attachment directing that such property shall not be transferred. That police sub-inspector will pass an order for attachment of the property. However, that such property shall not be transferred or otherwise to it, except with the prior permission of the officer making such order. And a copy of such order shall be served on the person concerned. Now, any order made under subsection 1, who will pass an order? That the sub-inspector will seize that property. When the sub has reason to believe that property will be concealed or otherwise disposed of, then or transferred, then such a sub-inspector who is conducting inquiry may seize. He may also, if necessary, pass an order of attachment prohibiting the transfer of that property. So any order made under subsection 1 shall have no effect unless the said order is confirmed by order of the said court within a period of 30 days of its being made. So that order of the sub-inspector of police seizing that property or attachment of that property will automatically vacate unless that is confirmed, that is approved, that is within a confirmed by the court within 30 days. Now 105F says, management of property seized or forfeited under this chapter. When the property is seized, what property is seized? Proceeds of crime. That means any property which has been derived or obtained by committing an offense. If that is seized, the court may appoint the district magistrate of the area where the property is situated or any other officer that may be nominated by district magistrate to perform the function of an administrator of such. When that property is seized, then the court may appoint either district magistrate or any other officer that may be nominated by the district magistrate to perform the function of administrator of such property. Now, the administrator appointed under subsection 1 shall receive and manage the property. Once that administrator is appointed, he will receive the property, manage the property in relation to which the order has been made under subsection 1 of section 105E or under section 105H in such manner and subject to such condition as may be specified by the center. The administrator who will be appointed as administrator to manage that property, the district magistrate or any other officer nominated by him will be appointed by the court as administrator of such property. Property, which property? The property derived by committing an offense, that is, which has been seized by the officer, some inspector, who has been directed to make inquiry. The administrator shall also take such measures as the central government may direct to dispose of the property which is forfeited to the central. If a property is forfeited to the central government, then administrator will take such measure as is required. Now 105G says, notice of forfeiture of property. If as a result of the inquiry, investigation or survey under section 105D, the court has reason to believe that all or any such property are proceeds of crime. First, court has reason to believe that the property which has been at the proceeds of crime, it may serve a notice upon such person, herein referred to know as the person affected. It may serve such person, calling upon him within a period of 30 days, specified in the notice to indicate the sources of income. If a court believes, or has reason to believe that after such taking such result of the inquiry and investigation, the court has reason to believe that such property will be proceeds of crime, then in the serve a notice who will be affected by such order, calling upon him within that means from whom it has been seized within a period of 30 days, specified in the notice to indicate the source of income, which source he got it, earning or assets out of which or by means of which he has acquired such property. The court will also ask the evidence on which he relies and other relevant information and particulars. The court will ask to produce such and to show cause why all or any of such properties, as the case may be, should not be declared to be proceeds of crime. That will not be declared as proceeds of crime and forfeited to the central government. Where a notice under subsection 1 to any person specified on property as being held on behalf of such property, any other person, a copy of the notice shall also be served upon such other person. That is where a notice under subsection to any person specifies any property as being held on behalf of such person. Suppose that person says, is that holding that property on behalf of any other person, the notice will also be served to that person to show cause why that will not be treated and declared as proceeds of crime. Now, as forfeiture property in certain cases, the court may, after considering the explanation, if any, court after considering the explanation, and to the show cause notice issued under subsection 105G, and the materials available before it, and are after giving to the person affected original this in a case where the person affected holds any property specified in the notice to any other person, a reasonable opportunity of being had by order record a finding. Court will record a finding whether all or any of the properties in question are proceeds of crime. Court will record. Provide that if the person affected, and in a case where the person affected holds any property specified in the notice to any other person, such other person does not appear. Suppose that person doesn't appear, or such person, the person who has been served with a notice, how it will not be treated as declared as proceeds of crime. It doesn't appear. Represent his case before it within a period of 30 days as present. In the show cause notice, the court may proceed to record a finding under the subsection ex parte. The court will record a finding that is the proceeds of crime ex parte on the basis of evidence available before it. Where the court is satisfied that some of the properties referred to in the show cause notice are proceeds of crime, but it is not possible to identify specifically such properties. Who finds the court is opinion that some of the properties are proceeds of crime, but it is not possible to identify from which sources they are bought, then it shall be lawful for the court to specify the property which to the best of its judgments are proceeds of crime. If the sources are not there, but the court may also record, give a finding to the to which property to the best of its judgments are proceeds of crime, and record a finding accordingly under subsection. When the court records a finding under this section to the effect that any property is proceeds of crime, court records a finding that any property that is a proceeds of such property shall stand forfeited to the central government free from all encumbrances. So now, deemed provision is there. Once the court declares that the property is the proceeds of crime, then such property shall stand forfeited, automatically stand forfeited to the central government free from all encumbrances. Then, where any shares in a company stands forfeited, suppose a share in the company, somebody by proceeds of crime purchased a share in a company, that is forfeited to the central government under this section. Then the company shall notwithstand anything contained in the Companies Act 1956, that is, or the article of association of the company, forthwith register the central government at the transferee of such shares. So, suppose derived from the proceeds derived from obtaining time from any company, so a share in a company has been purchased. So, but the court declares that will be forfeited. That has been acquired from the proceeds of crime. Then that will stand forfeited to the central government. So, in such case, if any share of the company is to be forfeited, then automatically that will be the forthwith register of the central government as this in the article of association of the company. Then, notwithstanding contain anything in the Companies Act or article of association, that will be forthwith registered that the central government is the transferee of such shares. Fine lieu of forfeiture. Sometimes, without forfeiting the property, some fine may be levied. What it says, where the court makes a declaration that any property stands forfeited to the central government under section 105A. 105 is proceeds of crime, that will forfeited. And it is a case where the source of only a part of the property has not been proved. Source part of has not been proved to be satisfactory. It shall make an order giving an option to the person affected to pay in lieu of forfeiture a fine equal to the market value of such. When suppose some property was seized, a part of the property court holds that is the court based on the judgment of the court that a portion of that property is the proceeds of crime. But the source of the crime is not known. In such case, the court shall make an order giving an option to the person who will be affected by forfeiture of that property to pay in lieu of forfeiture a fine equal to the value of that property. Before making an order imposing a fine under subsection 1, the person affected shall be given a reasonable opportunity of being, because Mr. Justice demands, requires that Before passing an order for imposing a fine, the person who will be affected must be given an opportunity of being heard. Where the person affected pays the fine due under subsection 1. Suppose court imposes a fine within such time as may be allowed in that year. The court may by order revoke the declaration of forfeiture under section 105. Court will declare the revocation of that forfeiture under section. The fine is paid. And thereupon such property shall stand released. Certain transfers to be null and void. Suppose the court has, where after the making an order under subsection 1 of section 105E, or the issue of a notice under section 105G, that is declaring somebody that property in the proceeds of crime, or if a notice has been given, any property referred to in the said order notice is transferred. Suppose that property is transferred by any mode whatsoever, either by gift or by sale, etc. Such transfers shall, for the purpose of the proceeding under this section, be ignored. Then once such order has been passed, such transfer will be ignored. And if such property is subsequently forfeited to the central government under section 100, then the transfer of such property shall be deemed to be null and void. If the court passes order such property will be forfeited to the central government, then such transfer will be null and void. Now, 105L, application of this chapter, the central government may, by notification in the official gazette, direct that the application of this chapter in relation to contracting state with which reciprocal arrangement have been made, subject to such conditions, exceptions, or qualification as are specified in this notification. That means the central government is given the authority to modify the notification regarding reciprocal arrangement whenever required. This section 105L. Now in nutshell, though it is a section, what is reciprocal? Not only this chapter not only deals the reciprocal assistance arrangement, but also deals the provisions for forfeiture of proceeds of crime, seizure and forfeiture of proceeds of crime. Now, in the chapters 8, in chapter 8, you find security for keeping the peace and for good behavior. This chapter 8 deals security for keeping peace and for good behavior. Let us discuss the provisions in section 106 of the Criminal Procedure Code. What section 106 provides? That the court of sessions or the magistrate first class, when convicts a person and sentences him for certain offences, certain categories of certain types of offences as provided in section 2, the court may, while passing a sentence on such person, order that such person will execute a bond with or without surety for keeping peace for such period not exceeding 3 years. So what it says? Section 106 will be applicable when there is a conviction. By which court? By the court of sessions or the court of magistrate first class. Of which type of offences? The offences are provided in subsection 2. Categories of offences. Those type of offences, when a person is convicted and sentenced by a sessions judge or magistrate first class, then the court, while sentencing that person, in addition to imposing sentence, may direct that such person will give a bond either with surety or without surety for keeping peace for a period not exceeding 3 years. So 106 is applicable when there is a conviction. By what? By which court? Second class magistrate cannot take. Only by the court of sessions or court of the magistrate first class. Now go through the provisions. Security for keeping the peace on conviction. So here somebody is convicted when a court of sessions or court of magistrate of the first class convicts a person of any of the offences specified in subsection 2. Subsection 2. Subsection 2 provides what are the offences or abetting any such offences or conviction for abatement of such offences, and is of opinion that the court is of opinion that it is necessary to take security from such person for keeping the peace, not only convict such person for the offences as provided in subsection 2, and his opinion that security should be taken from that person, from that convicted person for keeping peace, then the court may, at the time of passing sentence on such person, not at the time, thereafter not, at the time of passing such sentence of such person, order him to execute a bond with or without sureties, either with surety or without sureties, for keeping the peace for such period not exceeding 3 years as it thinks fit. 3 years maximum bond period may be 3 years. What are the offences? The offences referred to in subsection 1 are any offences punishable under chapter 8 of the Indian Penal Code other than offence punishable under section 153A and 153B and section 154. What is chapter 8? You go through the chapter 8 from this section. Chapter 8, that is from section 143. What is offences against the public tranquility? There, bond may be taken for keeping peace other than the offences 153A, promoting enmity between two person between these classes, 153A and 153B. 153B, that is imputation, assertion, prejudice to the national integration. So that is public tranquility. That is chapter, that is any of the offences from 143 to 160. Now, second, any offence which consists of or includes assault or using criminal force or committing mischief. In such case, any offence which consists of or includes assault or then using criminal force or committing mischief. Any offence of criminal intimidation, that is 506, criminal intimidation, or any offence which are intended to know or likely to cause a breach of the peace. Or if the conviction is set aside on appeal or otherwise, the bond so executed shall become void. Suppose in the appeal or otherwise that conviction is set aside, then the bond which has been executed shall become void. An order under this section may also be made by an appellate court or by court when exercising power of this order of taking bond or keeping peace for a period not exceeding 3 years for the offences as provided in subsection 2. Such order can be made by appellate court or when exercising the power of appeal or revision. Now you are sure, you are clear what is section 106. 106 provides only the court of sessions of the court of magistrate while convicting a person for any of the offences. What are those offences? Are offences affecting public tranquility or assault or criminal intimidation. Then in such case, the court is of opinion that bond should be taken from the convicted person from keeping peace. Then at the time of passing sentence, such court may direct that person to execute a bond with or without sureties for keeping peace, not exceeding a period of 3 years. Then suppose in appeal that conviction is set aside, then the bond which has been taken, that automatically comes to an end. That becomes void. Similarly, such a bond, the appellate court or the court exercising revisional power may, while imposing sentence, while sentencing a person for any of the offences as provided in subsection 2, and his opinion that bond should be taken from that convicted person for keeping peace by him, then the court, such court may also direct such person at the time of passing sentence may direct that such person should execute a bond either with surety or without surety for keeping peace not exceeding 3 years. In this chapter, you should remember that section 106 and 110, the period of bond may be 3 years. Then 7, 8, 9, the period of bond will be up to 1 year. Thank you all. In the next class, we will discuss the other provisions.